Broadcast is now starting. All attendees are in listen-only mode.
Happy Tuesday, everyone. I just have a few announcements before we get started. Today's presentation is hosted by HR Simple in partnership with FordHarrison. If you have any questions, please enter them in the question box and we will get to them at the end of the webinar. And if you would like to view any more webinars or you need more COVID-19 resources, you can go to hrsimple.com/events. HR Simple provides federal and state-specific manuals. All of our books have COVID-19 chapters, which include telecommuting policies and agreements, how to handle pandemics in the workplace, and the Families First Coronavirus Response Act poster. Our speaker today also authors the Hiring, Firing, and Discipline for Employers book, and that is under our federal tab under the shop page. So on that note, I'm going to read a little bit about Frank and then we can go ahead and get started. Frank has successfully represented national retailers, healthcare providers, and various other, there we go.
Hey, and I can jump in and just give
own?
a very quick introduction to myself, if that's okay with you.
Absolutely, let's do it.
Sure. My bio is very lengthy, and it seems like over time it continues to grow, so I can make it a lot shorter. I've been a labor and employment attorney for 16 years. I have clients all over the country. I have a national practice. My firm, we have offices all across the country. It's funny, after having done this so long, my practice areas within labor and employment have grown substantially. Everything from labor issues, NLRB issues, FMLA, ADA, Title VII, OSHA issues, and benefits. I mean, it's really kind of runs the gamut. I'll say that just having only exclusively focused on representing management in my entire career, I think a lot of the advice that I'm able to provide is so tailored to what businesses need. It doesn't all end up being legal. It's just based on kind of the experience from having dealt with so many different employers, et cetera. A lot of what I'm going to talk about today is, return to work issues. There are legal issues, and there's also going to be, let's say, some things from new laws being enacted where there's going to be some new challenges from, let's say, from administrative agencies and the way they're approaching, and the way administrative agencies are approaching some of the issues that you're going to be facing in a different environment after return to work. So I'm going to cover some of those topics for you. I have a lot of experience with these issues. We won't be able to address every topic in detail. It's kind of an overview. But without that, I'll say that happy to answer any questions you might have. If we don't have time to get to them, we probably won't. Still enter them, and I'll try to reach out to you directly by email and get you a response to it. And happy to help. So I'm glad you're able to spend some time with us today. Anna, can you start the presentation? Excellent. Sure. Okay. So kind of the starting point for return to work, and this is just going to take a second. We all know that the impact that COVID-19 has had on the workforce. I mean, it's been the most unprecedented situation. It is a very unprecedented situation. I've never seen anything like it in my career. And I'll tell you, it's been interesting and fast paced in a way that and typically that is the case for me, but still new laws enacted and new environments, and everybody's adapting quickly. And so the outcomes for employers have been difficult, but also there's the human toll. And this slide kind of emphasizes that. I'm not going to read it, but that kind of sets the stage for we're returning to work after an unprecedented health disaster. And so that kind of sets the framework for how we move forward. Next slide, thank you. So there are so many issues that come up when we're thinking about return to work. There's FLSA implications, overtime issues, classification issues. People are going to be working in new environments. There are challenges that range from OSHA issues. There's federal guidance and administrative changes that are coming. And so there's a lot of potential challenges and options for you to consider. We're going to go through some of those as well. Okay, so the Department of Labor, nice little graphic, it just didn't fit on this slide. But the Department of Labor is right now working on rolling out a much more aggressive approach to enforcement. With the change of administration, there's different views. The politics don't matter. What matters for employers is there's going to be more aggressive wage and hour audits looking for errors with, let's say people working off the clock, for misclassification of employees, et cetera. What you need to know is you really need to get your FLSA house in order. Now, previously, and part of this is in the context of return to work, previously the DOL would settle violations for what you owe employees. There's been a real shift, and right now they're focused on not just getting what the employees are owed, but double that amount for liquidated damages, and they're not being very flexible about allowing employers to settle for less than that. So, there's some real challenges coming. Be ready for aggressive enforcement. Remote work remains a concern, especially in the context of the FLSA. So, as you know, the FLSA requires employers to pay non-exempt employees overtime for hours in a work week over 40. Now, monitoring and regulating remote workers is definitely an issue. You've got to make sure that you are keeping track of their actual hours and that nobody's working beyond those hours. It's not sufficient for you to say, well, they shouldn't have been on the clock. The standard is lesser than that. You need to be taking steps to actually control when people work and when they are on the clock and performing work. If you're not, you're going to end up with a big FLSA problem. So what constitutes work time, as we just discussed briefly? It's if you suffer or permit, basically if you are allowing an employee to work off the clock, even if they shouldn't be, you can be liable for that time. You need to make sure you have a policy in place that basically holds employees accountable for following your time management policies, and you need to make sure you have the right policies in place. Even if it's unauthorized overtime, you still need to pay it because you don't want to end up with an FLSA issue. But at the same time, you also want to make sure that you have policies in place so you can hold that employee accountable. So if it's happening multiple times, you can discipline and terminate for abuse of timekeeping or working off the clock. So simple issue: record, record, record. It's on the slide, but still, it's worth saying again. Do you have a remote work policy? Does it specify when employees are allowed to be working when they should be working? Does it, does it require them to take breaks when breaks are required by, let's say, state law? So there are there's some guidance from the Department of Labor on that if you want to look for more, but you really need to be very focused on ensuring that the systems or policies you had in place when the workforce was more in person or all in person are still being tailored to address the telecommute work from home environment and make sure that it still fits that scenario. So productivity is part of it. I mean, you've got to make sure you have a way to determine, how are you monitoring productivity? It's not just about preventing off the clock work. That's one aspect. But let's think about employees who fall under the executive exemption, meaning they have to supervise employees. Well, how are you going to demonstrate supervision in a, let's say, remote environment, work from home environment, partial work from home environment, as some people are coming back? If somebody says, hey, I'm not properly classified as exempt, we as the employer have the burden of proving that the exemption applies. So a lot of times somebody brings an FLSA action against you for, overtime benefits, and my clients say, oh, well, they have to prove their claim. Well, in a lot of ways, that burden truly falls on us as the employer. We're the ones that need to be maintaining the records, and the law requires us to prove the elements of an exemption. And so we need to be thinking about not just how to prevent off the clock work, making sure we have policies that specify that if an employee works beyond a certain amount of time or their time card isn't accurate, there's a way for them to correct, to reach out to management and have it corrected to reflect the accurate payroll. We want to put the burden on employees to a large extent to make sure their time is accurate. And we need a policy that also says that any violations of our timekeeping policy, any time off the clock is a violation of the rules and subject to discipline. Also, this is what we're talking about here, though, is falling within the exemptions of what we have to prove. How are we going to show supervision? That requires some thought and some consideration of what the job duties are of a specific manager who's supervising employees X, Y, and Z. How much interaction do they have? How much of the supervision, to a certain extent, is now being done by, let's say, an automated electronic system? You know, a lot of employers have monitoring systems, almost all do. So if it's monitoring to say, okay, this person's been on their computer for, you know, X hours, and the report goes to the manager that says this, well, how is that manager engaged other than reviewing the data? Just something to consider, and part of this is kind of getting you to think through issues you need to identify and figure out so that you can take a proactive response. Okay, so this is just kind of a build off of what I just required, what I was just discussing. So you have to address instances of, you know, off the clock work, and you need to make sure your policies are sufficient to do that. So I know these topics so well, sometimes I'll run ahead and not necessarily address it at the correct slide. So forgive me for that, but we can move on. Practical solutions. I'll just go over these. I'm sure I said them. Make sure remote work policies clearly state no work off the clock. That's absolutely essential. We need to have a system by which employees can verify that their timesheet is accurate, and a policy and procedure that outlines the steps for them to take if it's not accurate. That puts the burden on them to say, oh, my time's not accurate. That way, if we end up in this situation of somebody saying they worked off the clock, we can say, well, wait a minute, you were aware that you had to do X, Y, and Z if your time wasn't accurate. You know, you've had an opportunity to review it, you didn't do anything. And so you look a lot better in those situations. I've successfully defended many such cases, and having those policies can make me look really good as your attorney, because it puts me in a situation where I have an advantage. So make sure you have those policies. Okay, this kind of gets redundant. There's additional points I was going to talk about here, but one thing I will say is, in a part work from home environment, part in the office environment, HR needs to consider, we're talking about productivity. So how do we help frontline managers find ways to more objectively evaluate performance when employees are not right in front of them? You know, I can say, talking to my clients all over the country, that many are not coming back to the office at 100% strength, and they may never do that. You might, that's fine. But if you don't, one thing that kind of gets lost is, so how do we measure productivity? And I think that's one thing HR needs to be going to managers and talking about, hey, how can we start to make sure we are still measuring performance in an objective way? Let's say in a typical office environment, a manager may walk out of his or her office, go talk to people. They see somebody spending a lot of time on their cell phone, doing something like that in an office environment. That makes managing productivity a little easier. You see those issues, but you've got to figure out ways to manage productivity in a different way when you don't have direct interaction with someone. And so having discussions with managers and getting them thinking about how they're going to monitor productivity and control performance in a different environment. Be thinking about that and find a proactive way to partner with managers to start having those conversations. So I went ahead and jumped ahead and talked about classification, but think about your classifications. Go through the different ones. If you have the administrative classification, if you have the executive classification, that kind of thing. Look at the specific elements of those and figure out how you're going to demonstrate that somebody's properly classified based on all of those factors. Now, also with the new emphasis on enforcement from the Department of Labor, there is a real focus on whether your independent contractors truly qualify as independent contractors. The current administration is going to be rewriting the rules about whether an individual qualifies as an independent contractor or should be classified as your employee. And you really need to pay attention to that. If you have questions about it, the definition of what's going to qualify as an employee is about to be broader. Take a look at that. And so what I'm talking about here, and I'm throwing a lot at you, is be proactive with wage and hour issues. Think about them. Look at the elements of the exemptions. Look at your policies about off the clock work. You know, this is an area where I've handled these cases all the time, all over the country. I even can check Alaska off my list now, 2 cases in Alaska. But I'll tell you that being proactive and establishing the environment in which you are, let's say, making sure your exemptions are sound and no off the clock work occurs, and managers are educated on, you know, not telling somebody, hey, you were late today, you're not clocking, you know, you were late clocking out yesterday, so you're not clocking in for, 20 minutes and, after you arrived the next day. You need to make sure that you have an approach to this that's holistic and addresses those issues that can arise on all levels. When you do, you're in a really good spot. So how do we get employees to return to the office? That's kind of a hypothetical question that leads into the next slide. And I really liked this one. Obviously, the Tom Hanks from Castaway versus Tom Hanks in a suit. But to a certain extent, I think we can laugh and say, this is to some extent what we see. I can tell you that when I was working during the pandemic, it was more common for me to be in a polo than in a button-up and jacket. But so the way we get employees to come back to work is we basically tell them they need to come back to work. You got to be a little sensitive with it, and there's issues we're going to address with that are coming up. Potential legal issues. Okay, I can tell you that the number of OSHA complaints and whistleblower complaints that I've dealt with over the last year and a half has been probably at least double what I'd handled in the prior 16 years. And then that was a large number. And it's just simply because the number of complaints being filed with OSHA over alleged safety violations, over employees feeling like COVID is not being taken seriously, that's a huge issue. The Families First Coronavirus Response Act, it's still important. I'm not going to spend a lot of time on it today because it's now voluntary. And I'll tell you just from a management perspective that I don't think that it is in the best interest of a lot of employers to keep following the FFCRA unless they fall into some unique categories. So I'm not going to spend a lot of time on that, but participation in that is now voluntary. The Americans with Disabilities Act comes up in many contexts in the return to work environment, and we're going to cover those. And then there's also some discrimination issues that we're going to address under Title VII. And this is just kind of the tip of the iceberg. But I think these are kind of big issues to raise that will educate people on how to respond in certain situations that are likely to arise in the workplace. How to be prepared. I mean, the first step is a COVID-19 control policy. I've said that in a presentation before, and I had 100 questions about what is a COVID control policy? Well, it depends on what workplace you're in. It's tailored to the specific needs of your business. But it's just basically a document that outlines what steps you're taking to prevent the spread of COVID. There's a little bit more to it than that, but you need a COVID control policy. Kind of serves as a baseline for you to go back to for discussions and a lot of other things. You need to prepare to address accommodation requests, and we've also got to consider the implications that arise from all sorts of different scenarios. So do you have a legal exposure for not having a safe workplace? And the answer to that's obviously yes. Now, OSHA, as I said a minute ago, I've been dealing with complaints and whistleblower complaints galore about OSHA. Take these very seriously. You have to make sure you provide a workplace free of recognized hazards that are likely to cause or death or serious harm. That's the general duty clause. But there's also a lot of other standards that apply. Don't forget about your OSHA obligations generally. Moving on, I will say You do have an obligation to provide notice to employees when someone tests positive in the workplace. Do not say the name of the person who tested positive. If you need any guidance on that, it's pretty straightforward. There's a bunch of articles on how you do it. But still, also COVID-19 can be an OSHA recordable, and there is some leeway in the regulations right now that allow you to exercise some discretion to determine whether or not it was work-related. How you do that, you need to look at the framework and see the factors. So, COVID-19 control policy. So here's the thing. In January of 21, OSHA implemented basically stronger guidance. And they're basically putting more of a burden on employers than had previously been placed. And as you'll see in a minute, OSHA is getting directives to be far more aggressive in their enforcement actions against employers based on COVID-19. Well, the COVID control policy is necessary because they're getting much more aggressive. The Biden administration has been directing the Department of Labor, which is OSHA, they're an OSHA division, to push more enforcement actions. The guidance that we just talked about, and I can't go through all the guidance, it would be an hour-long presentation plus just on that, but that guidance is a first step towards seeing what mandatory requirements are likely to be. We expect them to come out with that and offer guidance that's more specific than just the general duty clause that is extended to a lot of COVID so far. Moving on. Now, this is March 2021, and this is part of the greater emphasis and focus on COVID-19 enforceability, creating issues for enforcement. Now, it's the National Emphasis Program. There's new directives being given to area offices, and basically, let me sum it up by saying, if you're in an industry where you have employees in close contact with one another, or you have employees that are complaining that your COVID policies aren't sufficient, or people aren't following the COVID policies that you have in place, or your COVID policies are insufficient, here's where things get complicated for you. With greater enforcement comes targeted inspections. This is a big emphasis. It's no longer the idea that OSHA is just going to respond when they get complaints. But now when they get complaints, they may not just also reach out to employers to provide just a quick written response. You are going to see a lot of targeted inspections. In fact, they began in late March, and the number has been large. They are really pushing hard for these targeted inspections. And any of you who've dealt with OSHA investigators showing up, you know what happens. They show up for one purpose. They look around, and inevitably they're going to see other things unless you are running a perfect shop. And so goal number one is to try to keep them out of there, which is being proactive with your strategies, your communication, letting employees know you're being proactive about it. Communication is a big part, and enforcement of your policies is a big part. You do not want an inspection. If it happens, not the end of the world. There's ways to handle it, even if they find some things. That's typically where someone like me comes in when there's an inspection, but into the picture, and can help kind of negotiate with them, find some areas where they may be on less steady ground in terms of citations they find, but you get the idea. With inspections on the rise, just be aware that they're taking a much more So this is an interesting, very interesting fact here. So OSHA's been issuing many citations. A lot of those have been coming up recently. The ones related to COVID have been appealed at a rate of 42%. So out of all the COVID citations issued, employers have appealed those at a rate of 42%. I found that shocking because I've dealt with OSHA regulations for years, and I've appealed a few here or there over the years, but it's not typical to have a lot of appeals. You try to work out an agreement on the front end if there's some issues and not have to go through that formal process. But the appeal rate typically pre-COVID, without COVID being an issue, is around 8%. So what is the reason for this huge number of appeals that have been coming out of COVID-related citations? And the answer is a lot of employers are doing a lot, but OSHA is still citing them because there was an outbreak of some kind. They didn't feel like they did enough. The guidance that exists isn't specific, which gives people like me a lot of leeway to argue that that doesn't meet the legal standard for a citation. And there's also a concern about how a COVID-19 violation could lead to civil liability in some contexts. That would be a large discussion. But that's just kind of, I think, an interesting fact for you to understand. A lot of COVID citations are on, let's say, somewhat shaky ground, which leads to a lot of appeals, and the implications of some of those citations can be bad for employers, and the legal framework is actually going to get stricter. So the appeals may continue, but it's going to be maybe on firmer ground. Be very aware of OSHA, and one way you're addressing your OSHA concerns is with a proper control policy, communication, etc. Okay, so the American Rescue Plan Act, this does have an impact on return to work and your continuing obligations. It made the FFCRA voluntary. I've given many presentations on it to clients, and I'll tell you that there's a lot of nuances in there. We're not going to get into those today, but if you are following the FFCRA, it is voluntary. Whether you should be doing that and whether it's in your best interest is debatable. It just depends on the circumstances. I said that before, but keep that in mind. You can continue receiving the tax credits under it, and you can continue receiving those until September 30th. If you're following it, be very careful. You don't want to make a mistake. You don't want to be voluntarily participating in a program that could lead to liability if you're making the wrong decisions. So a lot of times I think it's just better to leave it as voluntary and not follow it. Being said, there are reasons that some employers do it, and they have good reasons, but we can't address all of those. COBRA changes. Now, this is a huge issue especially for employers that handle sending COBRA notices in-house, and even ones who rely on a third-party service. So here's what this rule provides. Under the American Rescue Plan Act, employers are required to subsidize COBRA coverage 100% from April 1st through September 30th, 2021, which is the subsidy period. Now, I think it's on the next slide. If not, we may have to go back. Okay, yes. Okay, good. So as we all know, COBRA is available for 18 months. And we just looked at the COBRA eligibility period, April through September 2021. Well, who could possibly be eligible for this new COBRA subsidy? So let's think about an employee you fired, let's just say in December of 2019. Well, I'm going to sit here, December 19, you extend that for the 18-month period, and lo and behold, the 18 months extends into the COBRA subsidy period. Now, this new law doesn't extend and create longer times for COBRA, but if somebody who was fired, let's say in November, December of 2019, got the original COBRA notice, they declined it, you have to send them another COBRA notice letting them know that their COBRA is still available to them now for the subsidy period, and you have to send them out a notice, and then they get to decide whether to accept that COBRA coverage during that period, at which you, the employer, will be paying 100% of the premiums, but you get that back in the form of a payroll tax credit. So there are some real nuances to this that, once again, I could explain it all in great detail, but it would take up the vast majority of the program. And one of my goals here is for you to be able to identify issues. Now, this one is a huge one because it doesn't just apply, as I said, to employees who get terminated during the subsidy period. Let's see, April through September of 21. It impacts employees who were terminated previously who would still be on COBRA. Now, if they elected COBRA, previously, they're not impacted. But ones who declined it, but who would still be impacted by this based on the 18 months extending into the coverage period would. So if you're not familiar with this, that's an issue where you're probably going to need some advice. You're going to need some advice. You're going to need to learn how you're going to do that. And there's a lot of steps we could walk you through that are pretty easy to make this kind of a streamlined process. That being said, that's an issue. Be aware of it. If one thing I really want you to think about is you definitely have, if you weren't familiar with what I just said about COBRA, you need to become familiar with it. You need to do an assessment of people who have been involuntarily discharged, who fall within that category, and then we need to figure out what steps you need to take to address it. Now, the ADA, this is such a big topic. It arises in so many contexts and it can be difficult. So COVID-19 is generally not a disability in and of itself, but it can lead to disabling conditions. You have to be aware of regarded as discrimination under the ADA. Well, if somebody has some complications from anything it might be, and they get terminated, most employers are doing the right thing in my experience. But when that happens, they may be able to claim well, you regarded them as disabled, even if they weren't. Something to take into account. And you also are going to have to deal with persons who have, immune system issues that qualify as disabilities that may require you to engage in the interactive process to see if there's a reasonable accommodation. Can workers refuse to work? My general answer to this is no. Workers can't just refuse to work. But if they have a disability, ultimately that means, or they claim they have a disability, that means you have an obligation to at least engage in the interactive process with them and figure out, well, that's not true. If you have an employee who has a disability and they're seeking an accommodation, then you have an obligation to engage in the interactive process. If you see an employee limping, you don't need to go out to them and reach out to them and say, well, you might want to just because you don't want to get hurt, but you don't have an obligation to seek people out to offer accommodations unless it's completely obvious. And if it's completely obvious that they have a disability and they're failing to meet their job requirements, you may want to initiate it with that person. Generally speaking, though, you don't have an obligation to seek out and try to figure out if people have disabilities. In fact, that would be unlawful as a disability-related inquiry. But once somebody does come to you and raises an issue, kind of suggests they have a disability and may need an accommodation, you need to engage in the interactive process. I'm sure you're familiar with that process. We talk about it all the time in these seminars, and I know HR people are very familiar with it. But yeah, and so a key question, and this is a neat one. I've had it asked to me probably 10 times in the last 6 months. And so a worker expresses concern that someone in their household has a disability, and they're worried that and they're basically asking the employer to provide an accommodation to them, the worker, because of the possible exposure that could take place at home to someone who does have a disability. So the ADA protects against discrimination on the basis of association with one who's disabled. Think in your head, is the employer required to offer the worker who doesn't have a disability an accommodation to protect the non-employee with whom the employee lives? Let's go into the next slide. So we just talked about ADA prohibits discrimination on the basis of association. Do you have to offer an accommodation to the worker? And the answer is no. The law requires accommodation. You have to engage in the interactive process, determine whether you can offer a reasonable accommodation only to workers who actually have a disability. So if a non-employee with whom the employee is associated has a disability, you don't have to accommodate the non-disabled employee because of that person. There was some people who were suggesting that, but it's contrary to the law. So I felt like I would address that here. That's not a valid basis for accommodation. Be sensitive to the request and figure out if you want to do something. That might be fine, but you're under no legal obligation. Now, some people have gone to temperature checks, as you all probably know, that's permissible. And I'll tell you that I think some companies are backing away from them now. I don't know if it's good or bad. If you do conduct temperature checks, one thing I'll say is make sure you follow the proper procedures. But the other part of it is, which are available through the EEOC, but that also being said, is it a step if it doesn't, let's say, cause too much disruption to take just to make employees feel comfortable that you're doing something? Worth considering the optics of the steps you're taking, and also thinking about it in terms of, if you get an OSHA complaint, you reach out to me, for example, and I get to say, respond to OSHA, here are the steps we're taking. We're doing temperature checks daily. We have a COVID-19 control policy in place that provides for these steps to take place under different scenarios. We have frontline managers, talking to their employees about social distancing. So we have a mask wearing policy, et cetera, et cetera. A lot of the steps you're taking can help you if you do end up being targeted by OSHA. And just by you being able to objectively identify the steps you're taking to control it, if they have some sort of issue or problem with other things, you still show them that you're being proactive and taking it very seriously, which has helped me resolve so many issues that have arisen. So, are you permitted to ask questions about where an individual has traveled? I've seen employers at first during the pandemic, there was this idea you shouldn't travel beyond 50 miles, 100 miles, and you are permitted to ask employees where they've traveled. One thing I have kind of started to notice is some of the travel kind of related rules to some extent have been irrationally applied, in my personal opinion. Like, yes, if somebody were to fly to, a foreign country where we're seeing reports that there's a massive outbreak, then, or, locations that have travel restrictions because of it, yes, you may want to take some precautions and require quarantine if they haven't been vaccinated or something along those lines. But the question kind of becomes, you can inquire about travel and make a rational decision based on it. But I also think if there's COVID levels, let's say there's some hot spots, et cetera, but people are still going to be exposed even in their normal lives. It's not like it's going to go away. So I would say counsel on travel, yes, you can ask about it, and it may be important in some situations, but that's a judgment call. And I've seen some questionable travel policies, like the idea of if you leave your metropolitan area, you have an obligation to report it to your employer. Well, I mean, some people have left their metropolitan area to go to a farmer's market where they wore masks. It's basically, what's the difference? But then that was a requirement. Just think about that issue. You can ask about it, but how relevant is it? And if you want to identify hotspots for it, so be it. But anyway, that's my 2 cents on that issue. But you can do it. So maintaining your active workforce. Well, part of this comes from being proactive in the way you communicate. How are you going to be dealing with absences of COVID-19? You got to work with accommodation issues. You need to be sensitive to people's concerns. You need to communicate and communicate and communicate. And hopefully you have the proactive types of policies in place that allow you to address a lot of the concerns that are going to come up. My main thing is communicate, have the policies. Don't just make it your job as HR. Recruit frontline managers, educate them. They're the ones going to have to address some of these issues. You want a lot of them referred to you, but you also want them to understand and be able to communicate the company's position on what the proactive steps they're taking are, because you need them to enforce those proactive steps when they see somebody who's in violation. So one thing that's important is, I had an employer very early on during the pandemic. They called me and they said, we're really concerned. We've got some elderly employees here, some of them senior level. And they said, we are just really concerned. So what we did is we took anybody who was 60 and over and we sent them home. And we told them we were going to figure out some way to compensate them for part of the pay they're leaving, but we just wanted to make sure they were safe. Well, We fixed that very, very, very quickly, because what they just did is discriminated in violation of the ADEA. You can't make those kinds of distinctions based on age. That's a very, very important thing to remember. Regular discrimination laws still apply here. So, don't just pick a high risk group and say you can't come. Just take into account the regular discrimination laws you are familiar with and you applied in the past, and don't make COVID policies that result in outcomes that are based on those protected classes. Moving on. Okay, so this is kind of an idea of when you have people, let's say you have your control policy that requires masks, that requires social distancing, that requires, extra concern on lunch breaks, whatever it may be, that's tailored to your business. And, you've got to be very sensitive to these issues. If somebody's not going to wear a mask, for example, we may need to figure out, say, why are you not wearing a mask? If they don't have a good reason at all, then you may just move straight to, hey, look, this is a warning. You need to be sensitive, but at the same time enforcing these, your control policy guidelines to make sure that you're protecting the workforce as a whole. Having the guidelines and not enforcing them at all it makes it worthless, and it's really difficult. And I've had a situation where I had to say to OSHA, what they did is interviewed 28 people from a facility, and they went through and asked these individuals questions about how often they saw violations, and they said all the time, all the time, all the time. And they're like, oh, wait, I wasn't doing that. So the company did a great job of having policies, but they didn't do a good job of enforcement or making a serious effort to enforce them. And I will say that the lead HR person for that company, it's a large organization. This was at one facility, who normally would have taken the lead. She would have done a fantastic job with this, but without her leadership, because she was on leave, unfortunately, things kind of slipped through the cracks. Frontline managers were concerned about, okay, what do I say? How do I say it? I think you address these issues just like you would any other policy violation, with a little extra sensitivity, because there could be some underlying reasons that are causing the non-compliance that may lead us to interactive processes, potential accommodations, etc. And one thing I'll mention, I've got to, and that is, if you're going to take adverse action against somebody who is like adverse in terms of like termination or docking pay, something like that, if you have any doubts at all, consult with somebody first. Consult with somebody who knows the ins and outs. It's just a matter of 1 ounce of proper, good overview on the front end can save you so much on the back end. My 2 cents. Now, yes, the answer to this question was obvious. You can require your employees to wear protective equipment. Take into account some people have like a latex allergy. So if it's gloves, for example, you may have to get them another special type of gloves. Just take that into consideration, but you can require it, and you may have to make accommodations for some different types of things, whether it qualifies as a disability or not. Finding the right protective equipment can be an issue. I had the issue on this slide come up 3 times in the last month, which is crazy. But it's crazy in the sense of I never would have expected it. So what happens when an employee claims that wearing a mask aggravates their anxiety or some other mental health condition? How do you respond to that? Well, first of all, mental health conditions like that are disabilities. Well, they many times can be. Just kind of go ahead and assume on the front end it is. And so you may have to consider other options. I included a URL at the bottom of the page about Ask Jan. Now, they're an organization that spends a lot of time evaluating accommodations. They tend to write from an employee's perspective just because that's the nature of the organization, but they have some good resources. You could do anything from saying, hey, look, when you start to feel anxious, you can go take a break. Here's somewhere where you can do it that's socially distanced in a closed room, for example, where they're not exposed to others. The interactive process here is key. Talk to them, figure out how often it flares up, that kind of thing. And you may get to the point where you need to get an ADA questionnaire from a healthcare provider, but we'll discuss that in a second. Oh, we'll discuss it now. Okay, so how is managing leave one of the more difficult issues you have to address in HR? I don't think I have to wait for a response, which can happen, but the answer is managing it is very difficult. The ADA questionnaire is a very valuable tool to help you manage leave. It's a very valuable tool to help you manage accommodation requests. Now, you can't use this tool in every situation. You can use it when somebody does not have an obvious disability, when it's not obvious that let's say, for example, a person has, is in a wheelchair from, let's say, spinal bifida. Well, that person, obviously, you're going to be able to see has a wheelchair, and you're going to be able to recognize that that person has some limitations. You can engage in the interactive process with that person to a large extent without ever even thinking about needing a questionnaire, and it would be inappropriate to use a questionnaire in that scenario. When it comes to mental health issues, it's a prime example of a time when you probably can use it. Some situations can differ, but I think it's a very valuable tool for employers, especially if you are trying to manage leave and not just be reactive. You've got a million things going on with leave scenarios, and picking the right tool for the right time is very important. Now, there's only certain information you can include in the questionnaire. If you don't have one of these, don't just make one on your own. That would be a huge mistake. Also, what you include in the questionnaire depends on the specific circumstances you're facing with an employee. You don't want to go too far and seek something you don't need. And so if it's not a tool in your arsenal now, consider it, learn about it. If you need advice on it, let us know. But that being said, it can be a very valuable tool in a lot of contexts. And it's a way you could get information from, let's say, a healthcare provider that allows you to have a much better interactive discussion based on facts. So if you're having interactive discussions without one, and there's some conflicting information you're given, that's another possible opportunity for us to open the door for us to be able to seek information from a healthcare provider through this type of questionnaire. Don't create one, please, and don't just start sending them out. You've got to know how to do that. Now, can you ask employees to show proof of vaccination? The answer to that is absolutely unequivocally yes. I know some states have been toying with the idea of making it a protected category, but it's not a protected category under federal law. I don't know the laws in every state. But if it's not a protected category, there's no reason that you can't ask that question. It's nothing about it is a disability-related inquiry. There's a lot of reasons people are getting the vaccine or not getting the vaccine. But here's the thing. If somebody says, no, I haven't gotten the vaccine, and you say, well, why haven't you? That can open you up to potential liability under the ADA, because the reason they may not have gotten it, the answer to your question could elicit, well, the question you asked could elicit disability-related health information, and that would make it a disability-related inquiry, which is prohibited. So it starts to become a fine line when you ask why you haven't gotten vaccinated. My advice to employers, we're going to talk about requiring vaccination in a minute, but my advice to employers is to strongly encourage it. One thing, if you get a chance to, even if you're not going to ask a question, I'm very curious to know, and I know this from a huge number of my clients that I've asked the question, but would be very curious. If you could just enter, like, if you know that, let's say 20% of your workforce is vaccinated, or 40%, or whatever it might be, even if you don't ask a question, if you could just put a number in that question box of what percentage of your workforce is vaccinated. I'm very curious to see how that's working out in different states and different areas. It helps me kind of gauge where some people are where there's differences. Anyway, if you don't mind doing that, if you have that data, would love to just see it, and obviously would treat it as confidential. But anyway, yeah, so you can ask them if they've been vaccinated. Like we said, you look, here's where your problem comes in. When you ask for more information about vaccination, why you haven't, or if you're saying, well, do you have any health issues underlying it? it becomes complicated and it could be a disability-related inquiry, which is prohibited by the ADA. Be careful with that, especially if you're just going to encourage it. I would say, if you're just going to encourage it, I would say that you don't want to ask that follow-up question. Moving on. So the answer to the can we force employees to get vaccinated? The answer is yes, kind of. You would still have to make accommodations for people who have objections for disability-related reasons and for religious reasons. Now, requiring it is difficult in some ways because it's going to put a much greater burden on you. There's some states right now that are considering making vaccine status a protected category, so you couldn't require it in those states, but there's no law that prevents you from doing it, but you're going to have to meet a higher standard to require it across the board and take people off of work who don't get the vaccine. So if you're requiring vaccination and someone can't get it, and let's say you have, they meet the standard, which is actually direct threat, and so you keep them off. If they can't get it, you should go ahead and get out of your mind the idea that you're just going to terminate that employee. That wouldn't be a good move. Let's say if you can't accommodate it, they can't get it for whatever reason, but it is a direct threat, then don't fire them. There's an intermediate step. You could leave them on unpaid leave of some kind for a period, and see how, and bring them back when it's not a threat. To meet the direct threat standard is a high bar, which is one reason why I say, there's going to be people who have real objections to it. And for you to show that an individual who is not vaccinated poses a direct threat, you would have to show that basically the nature and severity for the potential harm of that person continuing to show up to work and the other factors on the slide are so great that they pose a direct threat to their own health and safety, or the health and safety of others. It's a really high standard to meet, and it's done on an individualized basis. You probably want to avoid this if you can, but it is an option. Okay, so like I said, it's risky to exclude somebody from the workplace based on the direct threat. If you are in the camp of requiring vaccinations of employees, and you have people who cannot get the vaccine for some reason, I strongly recommend you find someone who understands this area of law very well. You may have in-house, you may not. Regardless, get advice, because it's very easy to put yourself in a situation where you have good intentions, you are attempting to protect your workforce, but the standard you have to bear to prove it is high, and there will be counter arguments. And so we want to put ourselves in defensible positions where if there is a claim of some kind, we can defend it and put ourselves in the best position to be successful. And you can do that, like I said, 1 ounce of preventative, let's say, advice from somebody who knows exactly what they're doing can save you a massive amount of trouble on the back end. So much easier to get it right on the front end than it is to try to clean it up on the back if you make a mistake. Okay, so how do you assess in the direct threat scenario? And I'll tell you, I really think that the perfect example of direct threat, and some of my clients who are hospitals and research hospitals and healthcare providers, where all of their employees have direct interaction with patients, many of them, or I don't think I have any that have mandatory vaccination policies, but they have moved some people into roles that expose them to fewer individuals, more social distancing type of things. If you're not in the healthcare setting, you probably are not. That being said, I can think of depending on the exposure that certain classes of employees will meet, could possibly meet the direct threat standard. Generally speaking, you're probably not going to see that. But even if you require it, understand that you have to engage in the interactive process to see if there's some other way. Can you move somebody to another position where they're not exposed to the same number of people so that they can continue to work rather than just excluding them from the workplace? It's not just that simple. Take into account your other obligations to engage in interactive processes and, to consider alternative accommodations for people with disabilities that would prevent them from getting a vaccination. So religious beliefs, for religious beliefs, you do have an obligation to accommodate, as you know, but the standard's a little different than it is under the ADA. So undue hardship under the religious accommodation law under Title VII is you have to provide that accommodation if it doesn't impose anything more than a de minimis cost or burden on the employer. That's been interpreted to not necessarily be as easygoing as the language suggests, but you need to think about, well, how can we protect, how protected would an employee be in a workplace, let's say, that's been 75% vaccinated, and the individual who is seeking the religious accommodation is wearing a mask and socially distanced? Would that be sufficient to address their concerns and yours? What's the risk there, the true risk that they pose to others in that environment? I think you would need to take that into account. So there's a lot of burden on HR at the moment with these, the standards, the traditional standards being applied to an unprecedented situation. And you've got to be nimble, you got to be quick on your feet, you got to understand not just the law, but the regulations that apply them to try to take the correct approach in these situations. And it can depend on factors such as what percentage of your workforce is actually vaccinated. And is there some other way that you can help, segregate that person if that's really a concern of yours? So moving on. So here's kind of a key. These are key points. A couple of these are not on this list. Be proactive with the FLSA. Make sure your policies address off-the-clock work and that you have a number of different policies to address off-the-clock work. Number two, consider exempt employees' classifications under the remote work or home work situation. How are they still managing and supervising employees? Think about the duties. If duties have changed for people who fell under the administrative exemption, figure out how they're exercising managerial discretion as the main part of their job. It may have changed in nature and you haven't considered the impact on it. Take into account the DOL is going to be enforcing wage and hour laws far more aggressively than they have in the past. Make sure you have a COVID control policy. That's going to serve as a basis for us to respond to OSHA complaints. It's going to help you address the concerns of employees who are fearful of coming to work. It'll help you address people seeking accommodations. Okay, well, here's what we're already doing. What else do you need? What else do you need for us to accommodate you and allow you to work? Your COVID control policy is largely based on CDC guidance. Here's the CDC guidance. What beyond this do you need because of your situation? Is it a situation where you need to use an ADA questionnaire? If you use that and you know how to do it, it can be very useful, especially in anxiety and mental health related issues. Now, one thing I always come back to, I say raise all those issues, but don't forget about just HR best practices. Many of you have been doing this for a long time. You're, HR certified. You've dealt with scenarios with employees for a long time. Best practices still apply in this context. Know when to reach out for help. If you're not sure about something, find someone who does. Communication is key. It solves so many of your problems. Sensitivity and respect for employees goes a long way. It doesn't solve all problems. I clearly know that. My view of things is a little stilted to an extent, just because I represent employers and they only come to me with their problems, generally with their problems. And so I see the world, through the eyes of the problems they face. But kindness, sensitivity, and I would say kindness, reasonable sensitivity, and I would say a compliance mindset really do go a long way. So I think I'm right at the hour mark here. And I know I flew through a lot of material really quickly. Sometimes with these presentations, I know how many issues there are, and I want to get through those. If you have questions about some of the issues I raised, please don't hesitate to ask them. I'll be happy to address them. And it's been a pleasure speaking with you today. And I think that might be my last slide. Could be wrong though. Yes, okay. Oh, well, the last thing I'll say is very early on, I joined our coronavirus task force, and I did it because I thought, you know what? I didn't think it was probably going to amount to much. I was going to be a joiner, and little did I know I was walking into an emerging area of law that was going to take a lot of time and effort to learn. I'm so glad I did. It's really enriched my practice and really helped me provide so many clients with excellent advice all across the country. And it's something on which my firm, having the presence we do across the country, and working with a number of other incredibly talented lawyers on the task force, we're able to find individualized solutions that are sometimes creative for our clients, often are creative, that really have helped a lot. So it's been a real pleasure being on the task force. And if you have those types of issues, we're happy to share our expertise. And then the last slide is questions. So feel free to type out any questions you have. I'll be happy to get back to you with answers to those. And obviously my contact information is on the slide. I'm out of our Memphis office at FordHarrison. Practice everywhere, but practice in a lot of different jurisdictions depending on the situation, but based in Memphis. So if you ever need to reach out to me, please feel free.
We do have one question, Frank, if you have a moment.
Sure.
Awesome. Do you have to notify staff of a positive COVID test if the positive employee has been working remote?
No, you would only, if the employee who tests positive is working remote, then their exposure was not due to a work-related contact. I'm just applying common sense in that. I hadn't had that question come up before, but I wouldn't see a reason to notify individuals. I think the purpose of the notification would be in, like, let's say a factory setting or even an office setting where somebody tests positive. You're giving people notice that someone has tested positive. If they were working remotely at the time they tested positive and hadn't been exposed to anyone, I don't see any valid reason in law or otherwise to actually require notification to go to others. All that's going to do is cause people to think, oh my gosh, am I exposed? Or if there are some people working in the office space. So I would say no in that scenario. It's not work related. It's not OSHA reportable. And I would not stress over that one bit.
Okay, I think that was our only question. Frank's email is up on the screen, so if you wanted to shoot him any other questions, please feel free. And thank you everyone for sending over those percentages on how many people at your company are vaccinated. I'll be sure to share those with Frank. Thank you so much. Up on the screen is my email if you have any additional questions. I will be sending out the slides and a recording within 24 hours. You can go ahead and copy the SHRM code down as well. I just wanted to thank Frank one last time. He's with us a couple times a year. We're super appreciative of him presenting. You can go to our recorded webinars page to check out some of his past presentations for us. And on that note, have a wonderful day, everyone. Thank you so much.
Thank you, Anna.